Okay. Morning. I don't wish to rush everyone, but we've got a big agenda, so I should probably get started. Again, good morning to everyone, and a very warm welcome to FIFA and the first edition of the Football Law Annual Review. We're really very happy to be presenting this program today and to have so many of you coming here. So really thank you for coming. The program is the brainchild of my colleague, Dr. Emilio Garcia. He's in charge of the legal department here at FIFA. He hasn't been here very long, but it hasn't taken him much time to get the ball rolling, including with the development of this new program. As many of you will know, we also have a president of FIFA who's a bit of a lawyer himself. He's actually a very good one. I wasn't either asked or instructed to say that. But he's 200% supportive of this initiative. Unfortunately, he can't be with us today, but he promises to make himself available for future editions of it. So today we're going to cover the full spectrum of the legal work undertaken here at FIFA. That includes an overview of FIFA's main regulatory framework and recent modifications made to it. We will also cover commercial legal matters, in particular the fight against piracy and our brand protection programs. We'll be talking about proceedings before the Ethics Committee and the Disciplinary Committee, and also taking a look at some of the leading recent cases. We'll be discussing the FIFA regulations on the status and transfer of players, and also looking at some of the recent case law there as well. We will also cover the latest news on TMS, global transfers and compliance. We will provide an update on the work of the task force on the player transfer system. As many of you will know, the player transfer rules have been broadly the same since 2001, when a settlement agreement was reached with the European Commission. Of course, a great deal has changed in the football economy in the last 18 years, so it's a good time to take a look at that system again and to consider whether it is fit for purpose, whether it's serving the objectives that it was originally intended to. Then we'll be taking a look at some of the major cases before CAS that have involved FIFA. So it's a pretty comprehensive overview of what we do here, and I would really like to thank Emilio and his team for putting in so much hard work to make it happen. And, you know, as a final general remark, I'd like to say that the key thing underlying today's session and this whole initiative is really the issue of transparency. In other words, openness about FIFA's legal rules, structures, and decision-making practice. Transparency can solve a lot of problems in life, and we really want to be transparent in what we do. I think we even have some representatives of the media here today to prove it. So all inputs, dialogue, and constructive criticism more than welcome. I hope you enjoy the day. Thanks again for coming, and I'll pass the floor over to Emilio. Thank you.
Good morning, everyone, and welcome to the House of Football, the headquarters of FIFA here in Zurich. I would also like to welcome those from all around the world who are following this event live on FIFA.com. First of all, thank you very much, Alistair, for your positive comments towards the FIFA Football Law Annual Review. and the whole FIFA legal team. It's a privilege for us to always count on your help and continuous support since we joined the company in September 2018. I promise to be very brief in this introduction. We have a very interesting program ahead, and what you don't need early in the morning is more opening words about this FIFA event. But allow me retain your attention just for a couple of minutes. Some time ago, a very good friend of mine, a Swiss lawyer by profession, who, by the way, is seated here in the FIFA auditorium today, shared with me some impressions about his first FIFA legal case. It was at the beginning of the 90s. FIFA had opened disciplinary proceedings against his client, a professional football player, for alleged violations of the FIFA anti-doping regulations. At that time, legal proceedings against the player were conducted in the following way. The FIFA ESCO sent a letter to the player in which it provided explanations on the alleged offense and invited the player to file statements within 10 days. After that, my very good friend got a letter signed by the FIFA General Secretary with the following content. Dear Mr. X, we acknowledge receipt of your letter dated XXX, and we would like to inform you that the player, Mr. XXX, has been sanctioned with 2 months ban for having consumed the following prohibited substance. This decision is final. We invite you to take good note of it and ensure its implementation. Zurich, 2nd of April, 1993, FIFA General Secretary, Mr. X. Thank God this belonged to the past, and the international sports federations, including FIFA, have changed a lot in terms of protecting and guaranteeing the rights of the individuals who are being judged by the disciplinary bodies. But do not lose the perspective. FIFA is not a perfect organization. We make mistakes, and definitely there is room for improvement, particularly when it comes to the transparency of the decision-making processes of our judicial bodies. It is in this context that the FIFA Football Law Annual Review is launched. With that in mind, and from now on, FIFA has set the objective of ensuring that football legal stakeholders get first-hand access to the most relevant aspects of the field. By launching this annual initiative, FIFA is opening its doors for the first time to present the regulatory work, case law, and the main decisions of its decision-making and independent bodies, as well as the main case procedures that derive from the arbitral tribunal in Lausanne. Apart from this activity, FIFA has the intention to transform its legal machine in the most transparent process known to international sports organizations. The Football Law Annual Review is just the first step. There is more to come. As from July 2019, FIFA has the intention to transform its webpage and publish the following key relevant information for the stakeholders. Legal decisions, leading decisions rendered by the disciplinary committees, the disciplinary committee and the appeals body. All decisions rendered with grounds by the adjudicatory chamber of the ethics committee. All case awards involving FIFA as a party. And of course, the list of case arbitrators nominated by FIFA within the so-called football leagues, and most importantly, the number of occasions in which these arbitrators were appointed in FIFA cases. We are also working on different projects from a regulatory standpoint. Definitely, FIFA has to guarantee legal aid and pro bono consuls to players who do not have sufficient financial means in the context of either disciplinary procedures or ethics proceedings. FIFA, and this is something that I believe since a long time ago when the disciplinary code was changed in 2011, we have the fiduciary responsibility to guarantee that all CAS decisions are enforceable. All CAS decisions are enforceable within the football system. In this regard, we have the intention to modify Article 64, the famous 64 of the Disciplinary Code, to enforce also CAS ordinary decisions through the FIFA system. Again, we are not a perfect organization, but what we can guarantee today is that we are fully committed to improve our legal standards and mechanisms in line with the FIFA Manifesto 2.0, the 2.0, the vision for the future, launched by President Infantino 2 years ago. Finally, I invite you today to share with the speakers, and of course with the FIFA administration, with the whole FIFA team, seated in this auditorium, questions, comments, or even better, criticisms. Here at FIFA, we welcome diverse opinions. A differing opinion is always a valuable factor which can help a lot to move ahead the entire system. So feel free to go ahead, not only with your comments, ideas, suggestions, feel free to put your criticisms first as well. Enjoy the first step of this process, the FIFA Football Law Annual Review 2018, and the very interesting presentations that the whole FIFA legal team has prepared, and I would add with a lot of passion, in order to be shared with all of you today here in Zurich. I wish you all a nice day, and thank you very much for your attention.
Thank you very much, Emilio. Also from my side, welcome to the home of FIFA. I would also like to welcome everybody following us on FIFA.com on the live stream. As the agenda will go, you will have a lot of speakers today. After each session, you will have the opportunity to ask questions to every speaker. We also have 2 networking breaks and a lunch break where I really encourage you to ask the speakers and the FIFA administration present all kind of questions that you would like to have answered, and to take the opportunity to exchange ideas with all of them. Since we have a very tight agenda, I will not continue to talk anymore, and I will pass the floor to our first speaker of the day. It's Oliver Jaberg, Director of Integrity and Institutional Legal, and he will give you an overview of FIFA rules and regulations in 2018. Thank you, Oliver.
Thank you, Maya. Good morning to everyone. So in the next 30 minutes, I would like to provide you with an overview on the key changes to FIFA's regulatory framework with a specific view to amendments of the FIFA Statutes, FIFA's Constitution, the FIFA Code of Ethics, the Disciplinary Code of FIFA, the regulations on the status and transfer of players, and last but not least, the FIFA anti-doping regulations. Now, with regard to the FIFA statutes, first an introductory remark. During the FIFA reform process, which ended at the time for this process in 2016, FIFA established a new structure and process aimed at ensuring the application of the principles of good governance, transparency, accountability, and compliance throughout the organization and the areas of our work. Since that time, we have gained more experience with the application of these principles and have seen that various adaptations to the FIFA statutes would be beneficial to their implementation. In addition, there have been further developments regarding best practices and good governance in sports that made it appropriate to amend or supplement certain aspects of FIFA's governance and regulatory framework, including the statutes. A dedicated working group consisting of 1 representative from each confederation, the chairman of the FIFA Audit and Compliance Committee, the chairman of the FIFA Governance Committee, was set up to draft necessary amendments to the FIFA statutes, and the following material amendments, which I would like to present to you, have been implemented and approved by the FIFA Congress in Moscow in June 2018. The first change to be found in the statutes is the new paragraph 2 of Article 4. This provision codifies FIFA's long-standing neutrality in matters of politics and religion, with possible exceptions with regard to matters affected by FIFA's statutory objectives. A further amendment concerns Article 25, paragraph 2 of the statutes. This provision sets out the process for notifying and convening the FIFA Congress in accordance with Swiss law on associations. Previously, FIFA member associations were notified in writing at least 3 months in advance of an ordinary Congress of the place and date of such Congress. In the new FIFA statutes, this time frame has been extended. Member associations will now be notified of the place and date of an ordinary Congress at least 4 months in advance of the same, whereas the deadline, at least 2 months before the date of the FIFA Congress to submit proposals to the Congress, remains the same. Another amendment concerns Article 27, paragraph 3 of the FIFA Statutes. The amended Article 27, paragraph 3 of the statutes further clarifies the procedure to be followed for candidatures for FIFA Council. In this respect, candidatures shall be submitted by member associations to the relevant confederation. The confederation shall be in receipt of the candidatures at least 3 months before the start of the respective confederation congress, on the occasion of which such election shall take place. Confederations then shall notify the General Secretariat of FIFA of all candidatures submitted to them within 5 days of the expiration of the 3-month deadline, and shall also provide FIFA with the evidence of timely submission. Article 40, paragraph 5 and Article 51, paragraph 8 of the FIFA Statutes concern an amendment with regard to related party declarations. Under this amended provision, the Audit and Compliance Committee shall now review the related party declarations submitted by the members of the FIFA committees instead of the FIFA Review Committee. In particular, since compliance aspects such as conflict of interest situations lie primarily with the Audits and Compliance Committee. Article 44 concerns an amendment on the competence of the Organizing Committee for FIFA competitions. Previously, futsal and beach soccer matters were in the competence of the Football Stakeholders Committee. This move to the Organizing Committee for FIFA competitions is intended to strengthen both games and make use of the expertise of the Organizing Committee and its members. Then, concerning the Player Status Committee, Article 46, paragraph 3 of the statutes was included. This is a new provision. The Player Status Committee and the Dispute Resolution Chamber have now been given the express power to pronounce the sanctions described in the FIFA statutes and the regulations on the status and transfer of players on member associations, clubs, officials, players, intermediaries, and licensed match agents. Article 52, paragraph 4 of the FIFA statutes has also been amended. Experience has shown that it often proves a benefit if the members of the disciplinary committee have a certain connection with the material under discussion. Therefore, only the chairperson and the deputy chairperson, but not all of the members of the disciplinary committee shall comply with the independence criteria in accordance with the governance regulations. Notwithstanding the foregoing, where a potential conflict of interest exists, the members of the disciplinary committee are, of course, obliged to recuse themselves from the case in question. Article 56, paragraph 2, letter H of the FIFA statutes has been newly included. In fact, a new disciplinary measure, compliance training for natural persons, has been introduced in the statutes in order to give FIFA bodies the power to pronounce a wider range of possibilities to ensure and enforce compliance and good governance. particularly over persons bound by the FIFA Code of Ethics, mitigating the risk of future breaches. In addition, certain amendments, in fact, of a purely formal nature have also been included in the FIFA Statutes edition 2018, such as the transitory provisions and provisions concerning enforcement in Article 75 of the statutes. The next topic is the overview on the amendments to the FIFA Code of Ethics. Short preliminary remark on the amendments to this code. I'm sure we all agree that FIFA bears a special responsibility to safeguard the integrity and the reputation of football worldwide, and is constantly striving to protect the integrity and image of football from jeopardy or harm as a result of immoral or unethical methods. The role of the Ethics Committee is therefore of vital importance. Both the member associations of FIFA and the confederations, however, also bear a particular responsibility to ensure that the core principles of ethical conduct are rightfully implemented within their respective spheres of competence. Consequently, reforms to the FIFA Code of Ethics have been introduced with the aim, first, of ensuring greater transparency and understanding of the different proceedings, and second, of ensuring generally recognized standards of conduct across the football world, at FIFA, at member association, and at confederation level. The new Code of Ethics has introduced additional rules prohibiting unethical conduct by officials and kept or clarified existing infringements. Let me, at this stage, point to the new Article 27 of the revised Code. In the context of this provision, I would like to briefly clarify one aspect right away. The amendment to the title of Article 27, former Article 21, now reading bribery instead of bribery and corruption, was heatedly discussed in the media. However, it is important to know that this amendment in title was implemented in the first instance for reason of language clarity in the English, Spanish, and German versions. There is, you may have noticed, no change in the French version, where the article in question still reads corruption. Most importantly, this change in title does not have a material impact on the actual infringements that are pursued. The same conduct that was punishable under the previous code is still punishable today under the new code. Moreover, I think it is important to point out that the revised code is even more stringent regarding bribery, for example, by stipulating minimum sanctions of a ban from football-related activities for at least 5 years and a fine of at least 100,000 Swiss francs to punish any instance of bribery which did not exist under the previous code. Here I refer to paragraph 3 of Article 27. Also, additional rules prohibiting unethical conduct by officials were added. For instance, an additional article on defamation, meaning the act of communicating false information that harms the reputation of an individual or a group, was added. Such prohibition, which was not contained in the previous version of the code, exists in most legal systems and was added based on the fact that the world of football is also not immune to conduct that aims to tarnish the reputation of others. This article concerning defamation is not only here to protect FIFA, but also, and in particular, to protect any person covered by the FIFA Code of Ethics who may be subjected to discriminatory or defamatory statements. Concerning the rules of conduct that were included in the to be included in the applicable regulations by member associations and confederations, I refer you to Article 1 and then also Articles 13 to 29. The rules of conduct themselves, in accordance with Article 1, in fact, of the new codes, need to be implemented by member associations and also confederations. This shall enable the football world to have a standardized and generally recognized common agreement as to the conduct that is to be considered inappropriate by football officials. Such changes shall be implemented as soon as possible. Article 30 of the FIFA Code of Ethics provides for an exclusive competence of the FIFA Ethics Committee to investigate and judge the conduct of all persons bound by the code, where such conduct, first, has been committed by an individual who was elected, appointed, or assigned by FIFA to exercise a function. Second, directly concerns their FIFA-related duties or responsibility, or is related to the use of FIFA funds. If the relevant conduct does not come under one of these situations, the member associations and confederations, depending on the scope of the relevant conduct, will have competence to investigate and judge the matter. The competence of the FIFA Ethics Committee will, however, remain reserved. The Ethics Committee shall only be entitled to investigate and judge the case when said conduct has not been investigated or judged or cannot be expected to be investigated and judged by the relevant judicial body of the member association or the confederation concerned. In particular, should no proper proceedings be taken at national or confederational level within 3 months as from the matter becoming known to the FIFA Ethics Committee, the committee shall be entitled to investigate and judge the respective matter. This places more responsibility on the member associations and the confederations and will safeguard the football world's interest in making sure that any improper conduct is duly handled by the respective competent body. The next amendment concerns further specifications of sanctions in Articles 13 to 29. With a view to promoting transparency as well as legal certainty in ethics proceedings, the degree of sanctions has been further specified in the rules of conduct contained in these provisions. In particular, minimum and/or maximum sanctions have been introduced in each material article, promoting transparency, constant jurisprudence, and legal certainty. These minimum or maximum sanctions are binding upon the decision-making body with the exception of cases with repeated breaches in accordance with Article 10 of the Code of Ethics. Match manipulation, and I'm sure you all agree with me on that, has no place in football, and also in line with one of the priorities of FIFA 2.0, FIFA's vision for the future, the football community must be united in its response, sending out a clear and strong message against any form of match manipulation, which is one of the biggest threats to our game. Therefore, and in order to ensure effective handling of match manipulation incidents, the new Article 29 of the FIFA Code of Ethics aims at more effective handling of such cases, covering more situations and leaving less room for legal uncertainty and interpretation. With the extensive additions and the will and commitment to fight corruption and to safeguard the integrity of football, this provision is aiming to provide the FIFA Ethics Committee with appropriate and effective legal means in order to combat this key threat. Article 12 of the FIFA Code of Ethics then sets out new limitation periods for prosecution of breaches of the FIFA Code of Ethics. As a general rule, breaches of the provisions of the FIFA Code of Ethics may no longer be prosecuted after a lapse of 5 years, with the exception, however, of bribery, misappropriation of funds, and manipulation of football matches or competitions, which may not be further prosecuted after a lapse of 10 years. The limitation period can be extended by half its length and shall be suspended where criminal proceedings are formally opened. Furthermore, in case of repeated breaches, the limitation period shall start only after the last of the repeated breaches has occurred. Under the preceding version of the FIFA Code of Ethics, the limitation period for prosecution stipulated that, as a general rule, breaches of the FIFA Code of Ethics may no longer be prosecuted after a lapse of 10 years, except for the prosecution of bribery and corruption, which were not subject to a limitation period. The statute of limitations is, as we all know, a general principle of law that is applied in civil law and common law systems, as well as in civil and criminal matters. Reasonable due diligence should be applied when prosecuting infringements. If too many years have passed after the facts have occurred, an investigator or the defendant might have lost evidence necessary to prove or disprove the claim. This amendment will bring more legal certainty to the world of football by ensuring that potential infringements of the Code of Ethics are dealt with in a swift manner. A further amendment concerns Article 67 of the FIFA Code of Ethics, which has been newly included and concerns the plea bargain procedure. The provision introduces an expedited procedure of sanctions by mutual consent, so-called plea bargain, in order to enable the FIFA Ethics Committee to handle cases in an even swifter manner. Such a plea bargain must then be ratified by the chairperson of the adjudicatory chamber of the FIFA Ethics Committee once the parties, meaning chairperson of the investigatory chamber and the accused, have agreed. Thereafter, the sanction becomes final and binding. However, if any of the sanctions agreed is not complied with, the agreement is automatically revoked and the adjudicatory chamber will decide the case on the basis of the file. And last but not least, it is important to note that no plea agreement is allowed concerning sanctions relating to infringements of bribery, misappropriation of funds, or manipulations of football matches or competitions. Article 7 of the Code of Ethics concerns the amendment of the disciplinary measure of compliance training for natural persons. Then Articles 5 and 74, paragraph 2, provide, in particular with regard to procedural questions, a clearer separation of the two chambers. Article 81 and 82 have also been amended and concern the appeal procedure. Such appeal procedure has been actually considerably changed by allowing most decisions to be appealed directly to the Court of Arbitration for Sport instead of the FIFA Appeal Committee as stipulated in the previous version of the code. This two-instance procedure for most ethics-related cases not only ensures a more effective handling of appeals and potentially also a reduction of costs, but will also help the persons concerned to have their cases settled in an even more timely manner. However, and as briefly mentioned, decisions relating to match manipulation particularly should still be appealed to the FIFA Appeal Committee, given in particular their greater connection to the field of play than other infringements of the FIFA Code of Ethics. Articles 84 and 85 of the Code set out the new procedures for provisional measures. Such measures may be introduced by the chairperson of the investigatory chamber in cases in which the investigation procedure may be interfered with or where a breach of the Code of Ethics may have been committed and the decision on the merits may not be taken early enough. The maximum time of a provisional suspension has also been doubled, twice 90 days, better reflecting, in fact, the reality of such investigations. As a matter of principle, once final and binding decisions of the FIFA Ethics Committee will be published in an appropriate manner, increasing transparency and showing the effectiveness of the proceedings of the FIFA Ethics Committee. To conclude, the amendments enable the implementation of a more efficient procedure, clarify duties of confederations and member associations for implementing rules of conduct and sanctions in their regulations. They also clarify the competence of the confederations and member associations in general and, importantly, increase legal certainty and transparency. In the FIFA Disciplinary Code, only minor changes have been implemented. An important one, in particular from a practical point of view, relates to the communication with the FIFA Disciplinary Committee. According to the preceding version of the FIFA Disciplinary Code, the decisions of the Disciplinary and Appeal Committee were only legally binding if notified via telefax or registered letter. By the same token, the parties involved in disciplinary proceedings were not allowed to submit official documents to the judicial bodies via email. Over the years, the secretariats to these judicial bodies have witnessed a constant and general decrease in the use of telefax by all stakeholders, therefore only making it possible in practice for decisions to be notified via registered letter in order to comply with the applicable regulations. Against this background, and with a particular view to increase efficiency in communication and to reduce the administrative burden for the parties, the Council approved an amendment to the Disciplinary Code allowing email as a valid means of communication between FIFA judicial bodies and the parties to the proceedings. Separately, further revision of the FIFA Disciplinary Code is ongoing, including, and as mentioned by Emilio, relating to Article 64 of the Code, taking into account jurisprudence and experience of FIFA decision-making bodies with the Code, aiming, again, at transparency, increased efficiency of procedures, and increased legal certainty. FIFA 2.0, the vision for the future, states the FIFA president's clear intention to, amongst others, revisit the transfer system with all stakeholders. Also, he announced that FIFA would set in motion the Football Stakeholders Committee to evaluate, together with FIFA, some of the most important aspects for the future of football. In this context, in its second meeting in October 2017, the Football Stakeholders Committee unanimously supported the introduction of some amendments to the FIFA regulations on the status and transfer of players, and the Bureau of the Player Status Committee and the Council approved the specific wording of all amendments. Such amendments then came into force in 2018 in line with FIFA 2.0. As of 2018, the use of the international transfer matching system is mandatory for all international transfers of professional female players. This change is meant to ensure that football's authorities have more details available to them on each and every international transfer, increasing transparency of individual transactions and improving the credibility and standing of the entire transfer system. Moreover, Article 14, the code also provides for an amendment that allows for an easier conduct of proceedings, meaning the parties may now communicate in procedures before the Player Status Committee and the Dispute Resolution Chamber by email. In March 2018, the FIFA Council approved further amendments to the FIFA regulations on the status and transfer of players, which entered into force on 1 June 2018 and mainly concerned the relationship between professional players and clubs, including one of the central pillars of the regulations, the maintenance of contractual stability between these parties. In particular, the revised Article 14, paragraph 2 of the regulations give the parties a remedy termination of the contract with just cause in cases of abusive situations where the stance of a party, meaning either a club or a player, is intended to force the counterparty to terminate or change the terms of the contract. Also, the new Article 14b of the regulations now expressly addresses the situation in which a contract is terminated due to overdue salary payments. At least 2 overdue monthly payments, provided that the club has been put in default in writing and given a deadline to make the payments, now entitle a player to terminate his or her contract with just cause. Article 17 of the regulations now further specifies the method of calculation of the compensation due to a player in cases of breach of contract without just cause. In particular, a distinction is now made between players having remained unemployed following the breach of contract without just cause and those who have found new employment. Then, the new Article 18, paragraph 6 of the regulations concerns the subject of overdue salaries and expressly prohibits so-called grace periods, meaning contractual clauses granting the club additional time to pay amounts which have fallen due. An exception is made only for cases in which such grace periods are expressly allowed by collective bargaining agreements. Finally, the new Article 24b of the regulations grants FIFA decision-making bodies the power to impose sanctions on players and clubs should a monetary decision not be complied with. These sanctions will be part of the decision on the substance of the dispute and consist of, for clubs, a ban on registering any new players, either nationally or internationally, and for players, a restriction on playing in official matches. As a last item, let's have a quick look at some of the amendments to the FIFA anti-doping regulations. First, and also based on a suggestion by WADA, Article 3, Paragraph 5 of the anti-doping regulations has been amended. It now states that every player and/or team that has been identified for inclusion in a national or international registered testing pool is obliged to provide whereabouts information. Players may delegate the whereabouts provision to a designated team representative. However, and importantly, regardless of such delegation, players remain personally responsible for duly filing complete and accurate whereabouts information. The revised provision makes specific reference to already existing consequences stated in the regulations in case of failure to do so. Article 80, paragraph 4 of the regulations, and for the sake of clarity in this context and to avoid conflicting interpretations, has been included, specifying that time limits for filing an appeal shall start from the day following the receipt of the relevant documents. Moreover, Annex D of the FIFA anti-doping regulations was brought in line with WADA's requirements, and Annex E of the regulations has been amended due to data protection considerations. So this was it. I hope that I was able to provide you with an overview on the key changes to FIFA's rules and regulations. Thank you very much, and if you have any questions, I will be pleased to take them now or bilaterally during the coffee break, which I understand is after that the next item on the agenda, to which we probably all look forward to. Thank you.
Thank you very much, Oliver, for this presentation. It's a great overview about all changes introduced in 2018. Some of them then will be explained in different presentations. But again, thank you very much for the presentation. Just to clarify a little bit the word transparency today. So I'm seeing some friends taking pictures of the presentation, so it's difficult to say, so we are going to be more transparent, and at the same time, well, no worries, we are not going to share the presentations with you. So for sure, we are going to share the presentations with you. So the PowerPoint presentations, the idea is to upload not only the presentations, the full presentations, also the videos on FIFA.com as from next week. So unless you have a CAS hearing and you can benefit from the information tomorrow, and the hearing is tomorrow or on Monday, you don't need to take pictures of the screen, because this info will be publicly available as from next week. Having clarified this point, of course, any questions, comments, and of course, even more than welcome criticisms concerning all these changes introduced in 2018? Please go ahead.
Yeah, thanks for a very, very interesting presentation.
Please ask you to get up so that the camera can get you to stand up and to tell them to Thank you very much.
Yeah, I'm Anders Schuppenet from the Swedish FA. Thank you for a very interesting presentation. I have a question about training compensation for women players. From the Swedish perspective, we think it's justifiable and fair that also women professional players should have training compensation for the clubs that have trained and educated them. So I wondered when, not if, it's going to be introduced in the regulations. Thanks.
Well, thank you very much for the question, which actually is one to which I personally do not have a specific answer. I cannot tell you when this is going to be implemented, but what is a fact is that for FIFA, the furthering of women's football, the development of women's football is one of the key objectives. You will recall that a women's football division specifically aiming at the development of football has been implemented within the administration, and that FIFA takes the development of women's football extremely seriously.
Yeah, if I could just add to that, I mean, we have, as I mentioned, we have this transfer task force established. It's been working for over a year now, and it's looking at the whole mechanics of the existing transfer system, obviously, as that system applies to men. I don't personally see any reason why the discussion about training compensation for women could not become part of the agenda in that group. Probably it makes sense. I don't know the extent to which this issue, what the transfer market is really like at the moment for female players, but obviously to the extent that it is moving in a similar direction as the men's one, there's no reason of principle why you wouldn't have the same kind of funding, and in particular training compensation and solidarity, which is a key part of the system. It's actually a key part of the system that hasn't been working in the men's game, and that's one of the main elements of the work in the transfer task force, is to ensure that the training compensation and the solidarity amounts that are due are actually paid to the clubs that should receive them. So I personally think that it's an issue that we could look at in that forum as well.
If I may, and bearing in mind that the two ladies who are dealing with the global transfer, Erika, Head of Player Status, and Kimberly, Head of TMS, both are here. So maybe, Kimberly, you would like to add something. You have the figures, and you know very well the reality.
That was paid for women transfers. So as a result of that, I think it's very early days in the women's game, and something obviously that we would discuss in collaboration with the professional women's football department here at FIFA. But the question that you've raised is a very good one, and as Alistair says, it's something that we will be looking at possibly, but because of the money and how small the money is at this particular stage, possibly it's something to consider as we go forward. So you'll see there was only about 1,000 transfers in the professional women's game in 2018, and only about $500,000 US.
Any other questions? Enrique, here.
Here we have a question.
I was just going to add to what Kimberly said, to say that the first decision of training compensation taken by the DRC, actually the analysis that they made was at that point in time, both the representatives of clubs and players said at that moment in time, if they impose training compensation for women's football, that would hinder the movement because exactly of that. It's still early in the game. And then it was a similar approach to futsal players, that it was not, the professional was not in such a level that would already be possible to have training compensation paid. But of course, this should be revisited once it is in a level that is ready for training compensation.
In any case, as you can see, the global football transfer market is in the hands of two ladies. So, you know, it should be ready very soon, no? Enrique.
Thank you very much. Thank you for your presentation. Thank you, FIFA, for holding and hosting this annual review. I have a question regarding the amendment on the disciplinary regulations. Sorry, I didn't introduce myself. My name is Enrique Ripoll from Huerta y Crespo law firm in Spain. And there was a slight commentary on the disciplinary regulations amendments, but there's one that particularly took like my attention, and I'm sure that many of my colleagues, is that the fact that when after a procedure, the parties, after a dispute is decided, the parties reach an agreement, FIFA closes the file. So if the agreement is breached and it's not respected by one of the parties, then they have to start all over again with the DRC proceedings. So I would like to ask FIFA, take this opportunity to ask, what's the ratio decidendi behind this decision of, let's say, not facilitating the existence of these agreements, because at the end it was very useful for the parties to have an agreement which, if breached, there was the sanction pending in FIFA, and that was quite fast. Otherwise, we have to go back to the DRC and wait again 2 years to have a final decision. Thank you very much.
Okay, I think that Jaime will address this point. He was behind of the revision process in 2018.
Thank you, Enrique. Exactly. I mean, we know that some stakeholders didn't see this change as a positive one. From our perspective, what we saw and the experience that we had with the disciplinary committee in Article 64 cases is that clubs, and well, stakeholders in general, but mainly clubs also, were reaching agreements that were not solid enough, let's say. So with this circular, 1628, I think it is, the idea is to reinforce the system and give more responsibilities to clubs, to stakeholders, to associations, as you could see in general, so that if they do reach a payment plan or an agreement of any sort, it's an agreement that will actually stick, that will be respected, and that where, as in any other aspect of law, you manage to have some kind of guarantees in case that agreement is not respected. We did not want that guarantee to be disciplinary proceedings of Article 64 because in practice this meant an overloading of the system that ultimately led to delays and backlogs in our work. So in order for FIFA to also be able to provide a more efficient procedure, one of these ways was to avoid this kind of abuse of the system somehow, to enable that the guarantee that is used is the disciplinary committee will take action instead of looking for other kind of solutions between the parties. So that was the reasoning behind that change of approach.
Our former colleague and very good friend, James Johnson, now in Manchester City. James.
In the front.
Thanks for the introduction, Emilio. And thank you, Ollie, for the overview of the changes to the FIFA rules in 2018. I'm interested in the introduction of the plea bargaining in the FIFA Ethics Code. And if I understand correctly, there's no such process in the FIFA Disciplinary Code. So I'd just like to know why that is, what's the rationale behind having a process in one code but not the other. And I'd also like to know if we could see potentially a bargaining process in the disciplinary code in the future?
I will take this, particularly bearing in mind my fantastic experiences years at UEFA, in which they deal right now with the role of the discipline inspectors, and this kind of identical request is a plea bargaining, more or less the same system. Well, maybe it's a topic to say we are working on it, but definitely this is something that we are still consider. So internally with Mario, we have already discussed. It will require an amendment of the statutes, so for sure will not be in 2019. But we are considering the possibility to introduce first disciplinary inspectors, so someone who can help the administration or can take the lead of the investigations rather than the administration itself. This is something that we have already discussed. And my experience at UEFA, and then I think that the experience at UEFA now with Angelo is extremely positive. And on top of that, the plea bargaining or this identical request is something that definitely we are considered for the next year, because in terms of typical disciplinary proceedings, I think that it helps a lot. No? When you open disciplinary proceedings for 10,000 against the Spanish FA or 25,000 or 5,000, so it makes no sense to go for a long disciplinary proceedings with documents, decisions, so it's better maybe if we can reach an agreement, but this should be led by a disciplinary inspector, someone who can play a role outside the FIFA administration. That's why maybe it's a topic, but we are working on it, and this is something that we are considered most likely for 2020. Would you like to add something, Mario, on this point?
Yeah, we have a consultation process pending through Confederation for the amendment of the disciplinary code, and this topic has been already considered. Yes, James.
We have yes, upstairs we have another question.
My name is Frank Happy, Chairman of Cameroon Professional Clubs. Thank you for the invitation and for the opportunity given to us for this FIFA law review. My question is about the solidarity mechanism and the training compensation payments, which the cases are over-delayed. And we in Africa, sometimes the amounts are petty amounts, 1,000 euros, 2,000 euros, and for the clubs in Europe or America delay in payments because there's no penalty. Let's say the training compensation is 2,000 euros, 3,000 euros, until FIFA puts a pressure that you have to pay in 10 days. After 1 year, they still pay the same amount. Is there no possibility? Fine, the new regulation is already out, but for the future years, maybe some penalties must be put in place so that the clubs have some pressure to pay those training compensation and solidarity mechanism, which I understand was put in place by FIFA to bring down the money into football so that the little clubs can benefit from it. If it's big amount, we can understand when you're transferring Samuel Eto'o or Didier Drogba, but for local small players, 1,000 euro, 2,000 euro, it takes about a year or 2 years to get paid, and is really a problem to us, and it affects our game. Thank you very much.
I'll respond briefly, but then probably Kimberly will have something to say about this as well. I mean, you're right. The system's not working well. We estimate that I think it's between $300 and $400 million a year that would be due in training compensation, and solidarity amounts are not going back to the clubs that are entitled to them because there's no automaticity about the payments when an international transfer is made. And that's why, you know, one of the key topics in the task force is to establish a clearinghouse so that when an international transfer takes place, these monies will flow back to the clubs that are entitled to them. There's some people from the task force here. We've got Jerome and Julian, maybe other people, and it's one of the things that we've been focusing on. Kimberly's responsible mainly for the operation of the TMS system. and been taking the lead in this, and it's an important part of the transfer reform. Do you want to mention where we are, Kimberly?
Thanks, Alistair. That's exactly right, and we hear your comments loud and clear. You're exactly right. This is something we hear from other people, and all I would say is stay tuned for the rest of the program, because we'll be going into it in a bit more detail this afternoon. I'll certainly be covering it in my presentation. You'll hear from player status about how training and solidarity compensation work at the present time, and also my colleague Giancarlo will also be speaking about it. So we're on it. We're going to share it with you this afternoon, okay?
Good, so maybe we have one more question, and thereafter the gentleman in the middle has a question. Thank you.
Thank you. My name is Ali Topçu from the Albanian FA. You mentioned the widening of the responsibilities of FIFA, and I'm curious, under what circumstances would the Ethics Committee take action if the national associations do not take such actions? Or the confederations?
So the prerequisites to take action for the associations, they are stipulated in the relevant provision of the FIFA Code of Ethics. Now, as this provision is rather new, I think that it will be up to the Ethics Committee to fill the provision with life and to actually interpret the provision and exactly determine the criteria on the basis of which it would take action in case a member association doesn't. So as you have seen, the relevant provision is not too specific, leaves also some room for interpretation, and that will be the task of the Ethics Committee to specify that.
And if I may add, in the afternoon we will have Carlos Schneider, who would actually have his presentation about the ethics proceedings, where you then can certainly ask him also questions. Thank you. The final question, here the gentleman in the middle who has been, exactly, you're welcome. There you go.
Hello everyone, my name is Ghanem from United Arab Emirates League. I just have a question about Article 46 in the statutes, which is stating that the Player Status Committee as well as the Dispute Resolution Chamber may pronounce. Why it's may pronounce? It's optional, and based on what? Who will be observing that this decision can be pronounced, that disciplinary or the decision can be pronounced or not? Why it's not mandatory, why it's optional? And based on what it will be pronounced, the decision will be pronounced with the Dispute Resolution Chamber.
Well, you know, maybe Erika or Oli can address this point, but of course the wording of the provision gives the DRC or the Players Status Committee the possibility to take into account all the circumstances. That's why I can imagine who draft the wording used may. So it's an open possibility to consider the case, to take into account all the circumstances of the case, and then to render the decision. That's why the so-called legislator used this wording.
But
that's my...
I'm sorry, but we will be seeing, in some cases, we'll be seeing a decision taking the pronunciation of the sanctions in the decision. In other decision, there will be no pronunciation.
Yeah, right.
What is the basis on that?
Well, I think that it's a free decision of the legislator. So in some cases, it's not only with player status, it's also with disciplinary or ethics. So we have kind of standard provisions. So, and here I refer to the typical case of an ineligible player. So, you know, and there are a lot of cast cases in which you find that, you know, the room for interpretation is zero. So sometimes when you are cast dealing with an ineligible player, so, you know, maybe the decision is harsh, but, well, the consequences lie down in the provisions is, you know, the match is declared forfeited. So full stop. It's a free decision of the legislator. In other cases, of course, the legislator decides. In this case, it's up to the disciplinary committee, ethics committee, or the DRC. That's why they use may. So, and in this particular case, the legislator decided to use may in order to give the DRC, the Player Status Committee, more room for interpretation.
Yeah, but using the word may or the optional for the DRC and the players transfer without a clear grounds on when they are going to pronounce the sanction or not, and to keep it open, and it will be sometimes questioned why in this case it is pronounced the sanction, because the implementation of that sanction it will be in the personality of the FA. So in this sanction, I'll be on this decision. The FA is responsible to execute the sanction immediately. In other decisions, we need to go to the disciplinary committee and to file the case again in order to get the sanction. So there's no grounds. We don't know how it will be executed, how it will be in practical, why this decision is taken this grounds, and why is that decision is not pronounced with the sanction is not pronounced. So sometimes it will be unfair from my legal perspective.
I see the point, and I think that it is very valid, but in order to understand why and why not, we need to look at the decision. So in the grounds of the decision, the panel will analyze the case and will take this decision based on the circumstances again of the case. So, in order to understand why or why not, I think we will render decision with grounds. We are rendering decision with grounds, and in these grounds, in these explanations, you will see why the DRC player status decides in this way or in a different way.
Lastly, I hope just you will be monitoring the decision will be taken in the future according to this article, and to decide it should be either as obligation or you will be adding some grounds, so it will be clear for the DRC or for the players transfer if the decision is taken in a right way and in a fair way with every case or it is not. So just keep it in mind for future. Thank you.
No, thanks to you for the question. Would you like to add something, the player status, friends, ladies? Just a final comment before the break.
Yes. No, I'll just add, my understanding is this was amended in the statutes so Article 24 bis was possible, because before the sanctions for non-execution were done by the disciplinary. And so this was foreseen in the statutes to allow the Dispute Resolution Chamber and Player Status Committee to actually impose already in the decision the consequences of non-payment, which is, you're going to explain this afternoon, but basically this is the reason. It was foreseen in the statutes so that it is. And for all Article 24 bis, it will be explained this afternoon by my colleagues, then it will automatically be imposed, the section already in the decision. But this is something for this afternoon.
Thank you, Erika. So then I would say that if for now we could do the break, and you will have plenty of time to ask more of these questions in the afternoon session when you will have all the presentations of player status.
We have to be back
in 30 minutes.
In 30 minutes.
Yes.
So we have a break of 30 minutes, so we expect you to be around at around 10:45. Thanks.
Yeah. Ladies and gentlemen, thank you very much. Welcome back. I hope you had enjoyed your coffee break. We would like to continue so that we can actually more or less fit in all the presentations today. It's my pleasure to introduce you to our next speaker of today's day. It's Ian Smith, Director of Operational Legal, and he will provide you with some information about commercial legal. Thank you.
Okay. Thank you, Maya. So, as Maya said, welcome back to everyone, also to those watching online. What I'd like to do is, after looking at a hugely successful 2018 World Cup in Russia, is look back at the steps we took to protect our commercial partners. I'll speak first in terms of online piracy. I'll take a brief look forward towards Qatar 2022. And then my colleague Daniel will also speak on the brand protection program that we had in place for 2018. So, excuse me, gone too far. So, 2018 online piracy, obviously not a new issue. I mean, it's been around 10, 15 years. However, it's one that remains a serious and significant issue for rights holders and commercial partners. And therefore, we take a very serious approach to online piracy. For the World Cup in Russia, we had a team of over 300 people with our partners working on piracy, of which 130 were directly working on anti-piracy. The approach we took was, first of all, to send out notices to regular offenders. These are, if you like, these are not people who are streaming because they want their friends to see it. These are people who are streaming for often business purposes and revenue generating purposes. Often we know who they are and sometimes where they are. In those circumstances, we had actually some success where we saw drop-offs in numbers of streaming over the course of the tournament. We also saw that some of the numbers were lower than we'd anticipated in the first place. During the tournament, we with our partners had takedown tools which we used to remove live streams. We also suspended website domains. The issue with that, however, is that you can take a domain down one day and another can pop up 2 days later. It is moderately effective, but limited in duration. Then servers we blocked or removed. And then what we also provided for our media rights partners was the opportunity to send us links to potential piracy so that we could then take action. So obviously the more people you have eyes watching out for these streams, the more effective you can be. In terms of results, we were able to detect over 40,000 streams and take action in relation to those. If you think those 40,000 streams aren't only available in one place, they multiplied by thousands in terms of their availability. So to take down 40,000 is actually a big success. The platform with the highest number of live streams, 10,000, was actually Twitch TV, which is Amazon owned. Now, it provides a really good service, a really high quality service, which is why it lends itself to live streaming. But also, because they are such a high quality service, their takedown tool, which they worked with us to improve throughout the tournament, actually enabled us to take down all of those streams quickly and within 5 minutes of being discovered. So minimizing the impact on commercial partners. User-generated content live streaming, so streaming from homes, people in their bedrooms at home, still remains popular despite live streaming on social media, which is, as I'll go on to explain, exploded over the last 3 to 4 years. So live stream totals still increased by 12.2% over the course of 2014 to 2018 World Cups. For the piracy on social media is a relatively new phenomenon. I think it's grown rapidly in the last 3 to 5 years. And that's largely due to individuals who probably aren't aware that they're actually breaching copyright. They're simply sharing content with their friends. But it does mean there's a high volume. So it was important to have a strong technical solution, but also complement it with a cooperative approach with the social media platforms so that they could assist us and we could work with them to minimize the impact of this piracy. So we had a 24-hour-a-day program on various social media platforms. Before the event, we gathered as much information as we could together with our media rights partners to ensure that the takedown process could be as smooth as possible. One of the important parts of that was the whitelisting tool, which we gave our media rights partners access to, as well as FIFA's own channels, which meant we could whitelist our own channels and prevent them being taken down as part of the overall sweep when the piracy action was taken. That resulted in over 4,000 sites being whitelisted, and therefore our partners weren't harmed by our own anti-piracy actions. What we also did was to provide guidelines on how to use the whitelisting tool, as what we also provided was an ability to submit copyright infringement notices by the MRLs using the whitelisting tool. As I said, this was a technical approach that was complemented by a strong cooperative approach with the social media platforms. That was with the intention of improving the takedown times, so improving the period within which we were able to identify a stream and then remove it. With Facebook and YouTube, a claim API allowed for immediate action, so that's a manual process, but then once you've identified the stream, you can then quickly take it down. YouTube and Facebook, their own systems ensure automated measures also take down content. And exclusively on Facebook, they also allowed some of our partners to ingest their audio commentary, which again was done through our whitelisting tool and again helped to improve the speed with which the pirated content could be removed from the social media platforms. On other platforms where the tools weren't quite so sophisticated, we would send DMCA notices requesting a takedown of the reported content. The results are relatively self-explanatory. What you can see, though, is that in terms of the higher volume is actually with the videos rather than live streaming. And that goes to what I said before about this being generally individuals who are sharing content with their friends and not necessarily seeking to gain a financial advantage. Whereas the live streaming is much more minimal at the moment, despite the improvements in the technology on the social media platforms. Then just, as I said, moving on to Qatar 2022, the recent development in relation to the joint venture, which is FIFA World Cup Qatar 2022 LLC. The primary purpose of the LLC is to streamline the operational delivery of the World Cup and aims to improve efficiencies and control of event planning and delivery. So the LLC, if you like, fuses the FIFA's own knowledge of event planning and delivery with the in-depth knowledge of the Qataris in terms of the local culture, customs and objectives that they themselves have. So to explain how that will break down, the JV will undertake projects relating to event operations, so stadium operations during the event volunteer programs, whereas the Qatari Supreme Committee will remain responsible for the infrastructure that's required for the World Cup itself. And FIFA retains, as it always does, all of the commercial activities, media marketing rights, hospitality, ticketing and accommodation programs. So that is a quick travel through recent developments on piracy for the 2018 World Cup. And so I'd like to invite any questions that you might have before handing over to Daniel.
No questions at all? Well, this means well done. It has been all cleared.
Good.
So now we can continue then with our next speaker. Please join me in welcoming Danny Tony, the Head of Intellectual Property. Danny, the floor is yours.
Thank you, Maya. Thank you, Ian. Yes, I'm Daniel Zoni, the Head of Intellectual Property. In that capacity, I'm responsible for protecting and enforcing the brand-related IP assets here at FIFA. I'll be speaking about protecting our commercial rights as an example of the World Cup, and especially since last year we had a widely successful tournament. I'll be using that example. Just quickly, what I'll be speaking about. so the commercial rights that are involved, give some facts and figures also of how we commercialize these rights, move on to show you what the brand actually looked like. Then I'll cover the FIFA brand protection program, how we approach brand protection, how the operations are. I'll underpin that with some enforcement statistics and examples of infringements. And finally, I'll also touch on ticketing enforcement, which currently is under my remit also. Now, Ian already mentioned it was a very successful World Cup. This is exemplified by the fact that over 3 million people actually watched the games in the 12 stadia, in the 11 host cities. Over 3.5 billion people, and that is 45% of the world's population, in one form or another, watched it on screen. And 1.1 billion alone watched the World Cup final between France and Croatia. Since the since the online space is very, very important nowadays for commercialization purposes, just some facts and figures here. I'll highlight that 2.3 billion clicks happened on World Cup-related content on Facebook. And across the board of all our social media platforms here at FIFA, we have in excess of 123 million followers by now. Now, how does this translate into the revenue that's generated via the World Cup? The World Cup as our marquee event and as the pinnacle, basically, of single sporting events in the world, generates about 90% of FIFA's income. Out of those, and round about the budget in the 4-year World Cup period is about 5.7 billion, over half of it is generated by licensing the broadcasting and media rights. The rest is generated by licensing out the IP assets, so the brand-related assets, almost 32%, and then 10% are roundabout are accounted for by ticketing and hospitality sales. Who owns all the commercial rights? It is FIFA itself, so the association here in Zurich, unlike some other models where there's a holding company that licenses it back, we own all the rights, and we use the income that is generated to fund the FIFA administration. More importantly, though, the staging of all the FIFA tournaments and events. And I think most importantly, and that is 70% of all the income generated goes back into football and is used to funding our grassroots football and social development programs. Since I've spoken about that we license out our rights, and that mainly to our commercial affiliates, our partners and licensees, just a brief overview on how the commercial program is structured, or the affiliate structure. At the top, you have the FIFA partners who have the broadest bouquet of rights, so to say. They have access to all of FIFA's tournaments and events on a worldwide basis. Next tier is the FIFA World Cup sponsors who have rights to the FIFA Men's World Cup around the world, and finally regional supporters who have rights for the Men's World Cup in a certain region. There are 5 regions. And then, of course, you have licensees such as that produce and sell merchandise, and other stakeholders, for example, hospitality. Now, how does this translate into the brand and protecting the brand? Once an IP asset or an event asset is developed, so a logo, a mascot, etc., that is later licensed out, we have to protect it. The filing strategy, we protect it normally by trademark registrations. The filing strategy strongly depends on the event. So for smaller events, it will be rather limited, but for our marquee event, the FIFA World Cup, we file trademarks in and register the marks in more than 100 countries. In all the classes for the goods and services that our sponsors provide. And currently our portfolio stands around 12,000 registrations, which is quite large for an organization of our size. What was the brand? I think a lot of you have come across it. There are, of course, certain word marks that are associated with the FIFA World Cup and the organization. FIFA World Cup, Russia 2018, which identifies the event, the host cities plus years such as Moscow 2018, etc. Of course, and arguably the most valuable IP asset that we have is the FIFA World Cup trophy. Now, for every event, we create an official emblem, which in the current brand structure is based on the World Cup trophy. Then there is an official mascot, which for the last World Cup was Zabivaka, the wolf. There's a visual identity of the event, the official look, which draws heavily on the heritage and culture of the host country. Then there's an official poster, which for the last event featured Lev Yashin, the legendary Russian goalkeeper. There are host city posters for each host city. And finally, there's an official typeface, which in this case was Dusha, which means soul in Russian, and is developed specifically for the event and owned by FIFA. Now, how do we approach our brand protection program? First, what do we protect? Since the brand assets are at the core of our commercial program and a lot of the revenue generated depends on them, we, on the one hand, protect the value and integrity of the brand, but then, maybe more importantly, even so, the rights, the exclusive rights of our commercial affiliates. What do we protect against? What do we focus on? So it's IP infringements, ambush marketing, counterfeits, and unauthorized ticket sales and promotions. We do that year-round, of course, from the headquarters here in Zurich with my team, but during the event itself, we run a quite extensive on-site enforcement program to make sure that around the games there is no unauthorized commercial association with the event. Since not everybody here is an expert on brand protection and may not right away be aware of what these 4 infringement categories are, I think one of the most obvious is IP infringement, straight out IP infringement, meaning the unauthorized use of our trademarks, copyrights, and designs in marketing campaigns. So here the official logo being used in an online setting or offline for advertisement purposes. Then ambush marketing is typically a situation where a non-sponsor tries to free ride on the event by mostly not using our IP, but somehow in a textual or imagery references, creating the impression with the consumer that they might be a sponsor of the event. This happens in general in marketing campaigns, and there's a subcategory, and this is more like a technical legal differentiation of ambush marketing by intrusion, which actually refers to the physical presence of a non-sponsor around the event on a match day. And the typical scenarios are, for example, promotional teams of third-party brands outside the stadium, maybe a parked vehicle of a third-party brand close to the stadium, or, and this is probably the most known ambush in the football world from 2010, the Bavaria case, where a group of branded individuals that sat close together tried and, in that case, briefly managed to get some exposure on the live feed from a brand that is not actually a sponsor. Counterfeits, I think that's self-explanatory, fake merchandise. And finally, unauthorized ticket sales. That I just want to briefly mention because a lot of individuals or the general public is not aware of the fact that the only source, the only authorized source of tickets is actually FIFA.com and hospitality packages. But if there's any other space where you might buy tickets, they're not authorized and violate our ticketing terms and conditions. Now, how do we approach brand protection here at FIFA? We have a three-pillar approach, starting with communications, because over the years we realized that a lot of infringements are based on ignorance, if you so will. A lot of individuals, a lot of small businesses are not aware of the restrictions that come with intellectual property, are not aware of the restrictions that our commercial rights provide. And therefore, we try to raise awareness prior to or in the build-up to the tournament to avoid these issues and basically provide a service for the general public to stay clear of any problems. We do that in many different ways. One of them being we have a dedicated website, FIFA.com brand protection, where we also host our public guidelines on FIFA's official marks, a document that is geared towards the general public on understanding what the brand is, where the restrictions are. In Russia, we also established a National Rights Protection Committee, which was made up of all the government stakeholders, such as the Ministry of Sport, Prosecutory, Customs, Ministry of Interior, Police, Consumer Protection Agency, to raise awareness of the brand and to coordinate all our brand protection efforts. We present at conferences, we publish articles, we also send out preemptive letters to competitors of our commercial affiliates to put them on notice and to also basically tell them, listen, we're watching you. Next step, next pillar is surveillance. We of course monitor the marketplace for infringements and violations. We have external providers that help us do so, especially in the online realm. But of course, we draw very heavily also on our commercial affiliates. There are eyes and ears in the field, in all the jurisdictions around the world, but also on our external network of counsel. They keep their eyes open and will report if they see something in their home market. And finally, as I already mentioned, we have an on-site program during the event where we actually undertake patrols, and I'll get to that in a minute. Last pillar, and that is when we detect something, is enforcement. What is the legal basis of that? Of course, conventional legislation in around the world, trademark laws, copyright laws, but especially in the host country, and especially where there might be gaps in the conventional legislation for such topics like ambush marketing that are rarely codified explicitly. There will be a specific World Cup legislation that also touches on commercial rights, which gives us the tools to enforce against such violations. There are also FIFA-specific regulations, such as the media and marketing regulations, which put restrictions on what the sponsors and also delegation members, meaning players and coaches of the participating member associations, can do. And they're geared towards avoiding any ambush by such sponsors or, for example, a player wearing headphones by a third-party brand. Now, what is our approach if we detect something? The main goal is clearly to stop the infringement as quickly as possible, because the longer it's going on, the higher and more severe the impact is on the commercial affiliates and their rights. Once we receive a notification, and we do have a specific mailbox for that anybody can send a violation to, and we do receive also by the general public notifications of infringements. We assess the infringement, we assess the violation, and decide on the appropriate steps. That might either be an in-house approach. For example, just as an example, if Pepsi runs an ambush and I know my counterpart at Pepsi, I'll just give him a call and say, like, what are you guys doing? And very often it stops there. It's the most direct approach, the quickest approach. Or if an individual, whether it's rather clear that, or a small business, that the violation is due to not understanding the restrictions, we'll send them from FIFA a more friendly letter and explaining to them that they cannot do what they're doing. Of course, in more egregious scenarios, we do use outside counsel. Also in jurisdictions where we might not speak the language. In China, it wouldn't make a lot of sense of FIFA sending a letter in English. So we have Chinese counsel approach the infringer with a cease and desist letter. If that doesn't have the result that we are looking for, then we will engage in formal proceedings, if necessary, litigation. But to be honest, that rarely is the case. As I already said, we run a brand protection program on-site also during the event. In all venues, there is a FIFA brand protection venue manager that is typically a member of the FIFA legal team, supported by volunteers and by local authorities. And these patrol teams patrol outside the stadium before a match to make sure there's no unauthorized commercial activity around the stadium, and that nothing gets inside the stadium to stage an ambush in there. So we focus on the commercial restriction area and on the mag and bags, which are the security checks at the gates, to make sure that no unauthorized marketing material gets into the stadium. Now, all this theory, and also to show that we were quite busy in the last years, from an ambush and IP infringement perspective, we, in January to September 2018, had about 700 cases. And in the really hot period between May and July, most cases occurred, about 500 that we dealt with. Obviously, Russia being the most busy country, but closely followed by Latin America and Europe and Asia. In the online world, we mainly focus on online marketplaces to curb sales of counterfeits. The most infamous, so to say, marketplaces are eBay, AliExpress in China, and Amazon. And we took down offerings worth about 5 million euros worth of merchandise. In the social media space, we had reports of about 2,500 posts that infringed our IP. And we successfully took down 98%, so that was very successful and also very quick. Sometimes it took an hour or 2 hours to take something down from Facebook or Instagram, which is also based on our good relations with these platforms. Counterfeits. Main focus of the anti-counterfeiting program was on Russia. We took really a zero-tolerance approach there, did prosecute also very small amounts of counterfeits that we detected. Overall, we seized in excess of 1 million items in Russia or at the border. And this also led to, or had the effect that during the tournament, there was not a lot of counterfeited product in the market, and helped drive also sales for our official licensing program. Now, to move on to some examples of violations we detected. For example, use of the official logo by a third party, in this case, a mobile cell phone producer, in the setting of a broadcast of a qualification match of to the World Cup, use of our official event title in advertising for TVs in Kyrgyzstan. This was promotion for a public viewing event just outside my apartment, actually here in Zurich. They used the official font, and this was a little bit close to comfort, so they had to change their marketing material. Here from Egypt, where actually there's no use of any FIFA intellectual property, but in this case, the bank that did this promotion gave away tickets, which is a right that is reserved for our commercial affiliates. This one actually brought a smile to my face when I first saw this. Hooters, a chicken wing in the shape of our official trophy. We wrote them a cease and desist. They, of course, disagreed that there was any violation, but they took it down nonetheless, so I think internally they did agree. Also, very prone to ambush marketing activities are always beer brands. This was by Baltika in Russia, main competitor of our sponsor AB InBev. They also didn't directly use our brand, but the backdrop was very similar to our official look, and they stopped their campaign also upon our intervention. Here are some examples from online infringements. I mean, Facebook, again, the official look was used by Samsung. On Instagram, use of our trophy. And this one was a Twitter activation by Burger King, so obviously the main competitor of our sponsor, McDonald's, for the official draw of the World Cup. It was actually quite clever, so they replaced one of the countries with one of their sandwiches. But if they were really clever, they wouldn't have used our mark, so it was very easy to take down. Some examples of on-site ambush attempts, because actually we didn't have a single successful ambush that was widely publicized. So people that in branded clothing coordinate trying to enter the stadium. Typical things, flyers that were distributed outside the stadium, or unauthorized marketing material that is distributed to fans to bring inside the stadium. So, for example, Brussels Airlines had branded Belgium flags that they handed out on specific flights to Russia. But we confiscated most of those flags at the security checks. And finally, here is an example of ambush by an athlete, and this happened quite a lot. Performance socks by the brand True Socks. Performance socks in general, they're fine that the athletes wear them, but they're not supposed to be branded. And we had quite a lot of issues with True Socks, and these resulted also in disciplinary proceedings against some repeat infringing MAs. Just to give some counterfeit examples, very typical things, apparel, etc. I always have to laugh about, when you counterfeit first one brand, Nike, and then link it to the World Cup with the wrong brand, because our sponsor is clearly Adidas. Typical merchandise, plush, cell phone covers, etc. Also very typical, fake World Cup trophies. What a lot of people don't know, if you ever see a full-size World Cup trophy, it's by definition fake, because the biggest one we license out is this size, 15 centimeters. So any other one you see is fake anyway. We confiscated a whole bunch of life-size mascots. I don't know whether this was for Halloween or I don't know what. And now there's more atypical counterfeits. Maybe we should have a category for the official tomato of the FIFA World Cup. We confiscated 2 huge shipments of tomatoes from Egypt that sported our logo. I don't even know what the commercial purpose for that is. Vodka, apples, and sausages. And trust me, after a couple of days, we had to remove those from our offices. They were not very pleasant in smell. And as I said, finally, I'm going to briefly touch on ticketing enforcement. Some people might think, so what's our problem with people reselling tickets? Because quite honestly, from a commercial perspective, there is no, we already sold the ticket and made the revenue. But the focus there is different. It's on consumer protection. I mean, there's a ticketing pricing scheme that FIFA put in place that we believe is quite fair. And we want to avoid that people overpay. And normally people also don't understand that if they buy a ticket on a third-party website, such as Viagogo, for example, and Viagogo charges 10 times of what the ticket actually costs, that we have nothing to do with that. So the bad press, in the end, always falls on us. So there's a strong consumer protection aspect, and secondly, also a security aspect. Because if you buy a ticket through FIFA, we know who you are. And, for example, if you're blacklisted, you will not get a ticket. but we also can determine whether certain fan groups should be segregated because there might be hostilities in the stadium. Once a ticket is resold, we don't know who it goes to. So the security aspect or that initiative cannot be seen through. The main targets of our ticketing program are obviously professional resellers, travel companies that resell tickets marketed up, individual resellers, and especially online through platforms like eBay, on-site ticketing resales in front of the stadium, but there we try to have a lenient approach when it comes to the guy whose friend got sick and now he has a ticket that he has to get rid of. There we try to be more lenient. And of course, fake tickets or non-existent tickets, which we also had. Tickets that were sold by individuals or companies that just simply didn't exist. Just to put it into perspective, we had 7,000 violations, about 400 cases against professional resellers, with Russia the most, closely followed by Mexico and Morocco. And then online platforms, 90% of all violations were ticket offers on eBay. And we successfully took down about 6,200 of those during last year. This is where I conclude. Thank you very much, but of course I'll give the floor to questions, if you have any.
Thank you, Daniel. Do we have any questions for Daniel? No? Good. So if not, then
thank you very much.
I would like to give the floor to our next two speakers. We have Mario Galavotti, Director of Independent Committees, and Carlos Schneider, Head of Ethics for Secretariat of Investigatory Chamber and Disciplinary, very long title, who will speak about disciplinary proceedings. Mario, the floor is yours.
Thank you, Maya. Good morning. Good morning, everybody. Thank you for attending. Before entering into the topics of the disciplinary as well as ethics proceedings, let me have a very short introduction to a main change that we had last year in FIFA. As part of the reform process, last year FIFA created a new division, the so-called division of the independent committees, namely the Audit and Compliance Committee, the Governance Committee, the Review Committee, and of course the judicial bodies, of which we are going to talk more extensively later today. Before 2018, and before the creation of this new division, the separation of powers at FIFA was not clearly defined. And we had the legislative body and the administrative part dealing together with the so-called advisory bodies or the standing committees, including the judicial bodies, which were part of those standing committees. After the 2018, because the new FIFA statutes approved in 2016, and because the creation of this new division, the division of powers at FIFA is clearly defined. We have the political aspect, the political bodies, the legislative bodies, supported by the advisory bodies, which are the standing committees. And then we have this new division taking care, coordinating, in charge of coordinating the functioning of those so-called independent committees. And this division refers exclusively to the administration, but for the administration matters only. So the new division is totally autonomous, totally independent on how to run and how to organize its own job. As per the FIFA statutes, very briefly, the independent committees other than the judicial bodies are the Audit and Compliance Committee, which is ensuring the reliability of the financial accountings of FIFA and also oversees other financial and compliance matters. Within the Audit and Compliance Committee, we have a subcommittee called the Compensation Committee, which is in charge of determining the compensation rules or the compensation of the top officials of FIFA and Council members. The Governance Committee monitors the main changes of all the regulations pertaining to governance matters within FIFA, and is also advisor in terms of human rights, social responsibility, environment protection, gender equality matters within the FIFA activity. The review committee is formed by only 3 independent members and is in charge of conducting the so-called eligibility checks and as well as the independence reviews in connection to candidates or incumbent members of the FIFA body. As far as, you changed the color of this. As far as the judicial bodies are concerned, this is normally the path to a final decision of this issue, decision about concerning Disciplinary and Ethics Committee, and as we saw before earlier today, the main change that we had last year in FIFA was further the adoption of the new Code of Ethics, the full separation of the investigatory chamber and the adjudicatory chamber. Before, those 2 chambers were strictly connected, were very related one to the other. Now we have a full separation of the 2 chambers, and the decisions of the Ethics Committee can be appealed directly to CAS, other than the decisions concerning the match fixing, for which our appeal committee is still competent. So my colleague, Carlos Schneider, will show you in details our work, with main focus of the work done in 2018, and remaining within the disciplinary proceedings. Certainly we can say that the activity of a FIFA disciplinary committee is perhaps less visible in terms of media compared to the same activity of similar bodies at confederations level. This because we have the number of competitions at in FIFA is certainly lower than the competitions at the confederation level. However, you will see that the workload is massive, and the numbers that we have are quite relevant. In 2018, we had 975, about 1,000 cases treated, only 90 of which were related to the FIFA World Cup, to the main competition. And we had about 500 decisions taken during the 2018. But the main workload of the FIFA disciplinary committees comes from the so-called player status case and TMS cases. Those 2 areas, those 2 domains, cover more than 80% of the disciplinary committee of FIFA. And if you see this graphic, as far as the World Cup activities, or the 90 decisions that we taken connected to the main competition, we had only 40% related to the typical violation infringements on the pitch of play, players and officials and misconduct. 44% were related to the crowd disturbances facts, and the 16% were related to marketing regulation infringements, of which Daniel showed some example before. At FIFA, we don't have only the World Cup. We have other 11 minor, we'll say, competitions, but very important for the development of football. Unfortunately, those competitions do not keep us very busy as the other ones. But the main activity, the most important activity for the, as I said before, for the FIFA Disciplinary Committee is the implementation, the enforcement of the FIFA body's decisions, all the decisions, not only coming from the player status, but also from the DRC or other TMS or other FIFA bodies. So the situation before this circular, of which we mentioned it also earlier today, was quite heavy. The disciplinary committee has a very strong, a heavy workload. And so last May, we decided to change the procedural rules, to change the approach. And we tried to be not only more efficient, but also we tried to reduce our workload. Before that circular, before that procedures, we had a different situation where the disciplinary committee was abused, I would say, by the creditors, either clubs or players or other organizations, and they entered into a kind of negotiations with the disciplinary committee to keep the file open while they were eventually negotiating the payment plan of their credit. After this circular of May 2018, the situation is different. Whenever we receive a decision from PST or DRC not respected, and the creditor asks for implementation, we open a file. We, of course, inform the parties concerned and given a short term to submit their arguments or eventually to pay, to comply with the decision. And if this is not going to happen, we immediately release and issue the sanctions, asking the National Association to implement our decision, and the sanction could be either deduction of point, in this case, the National Association is ordered to deduct the point, or the ban of transfer, which in my opinion is the most effective sanction for a club. And as a matter of fact, you will see in a while that this new approach realized a quite efficient new system within the committee. We had only 29 decisions in the first period of the year before the circular, and then we had 253 decisions from after the circular in the following June-December period of 2018. So the workload is going to be reduced. In addition of this, we have the new regulation of the player status, where the DRC or the player status can impose the sanctions directly whenever they take a decision. So we estimate that within the end of this season, all the workload related to the past cases should be zeroed. One of the collateral effects, I would say, of the very positive introduction of VAR is also affecting the disciplinary committee. As you know, the VAR, the referee may be assisted by a VAR in the event of a direct card incident, and this created this result, this outcome. In the Russia World Cup, we had 0 direct red card. We believe, and so we had reduced the workload of our disciplinary committee, and for this we have to thank also the VAR. I would like to call Carlos at the podium to introduce the single cases and to talk about single cases. Do you want to come here? Okay. Thank you.
Thank you, Mario. Hello, everybody. Hello, world. Hello, family. So first of all, I would like to thank, obviously, Emilio and Alistair and Maya, the organizers of this tremendous event. I think, if I may, I think this is a great first step into something that we all think it's good for FIFA. It's this transparency, this forum of having all of you with all of us discussing matters related to sports law. So again, thank you for to be allowed to participate in this event and to speak about two of my passions in sports law, which are disciplinary now and later on, if you survive this short presentation, also ethics proceedings. So I know time is precious, again, because the will is not only that we present cases, that we present the topics, it's also that you are involved and we all start a common discussion on the issue. So I will try to be brief, to be concise. I don't know if when I was choosing the cases, it's only two, but I don't know if that is was a good option to start with this case, because it's quite challenging from a factual perspective, because it's the continuation of what we all know here is the Matusalem case. So I will try to be concise, I will try to be brief, but allow please a little bit of reservation on this statement, because again, the factual circumstances of this case is quite complex. So this case is about the application of Article 64. I witnessed that today we had already some discussion, some questions regarding this article, where my name was mentioned as well, so I'm fear that I may have other questions afterwards. So just to briefly give the context of this article, it's an article dealing with the failure to respect decisions. So as already explained by Mario, the process is clear. We have a decision. We have someone who is not respecting the decision. We have a specific procedure to enforce that decision. What happens is that normally FIFA says, okay, you didn't respect the decision, so we will provide you with a deadline, and if you are not respecting that, we will impose sanctions, like, for instance, appointed action. And this is more or less what this case is about. As I said, this is the factual circumstances, and everything derived in two different CASA words that were then jointly put together and decided together in one sole award. So this is where the challenging moment begins for me, how to explain this case very briefly and very shortly. So we have a club, which is Zaragoza, owing money to Shakhtar. Obviously, in that equation stands also the player, but for reasons that I think we all know, he was acquitted by the Swiss Federal Tribunal. So let's focus on the main actors here, which are Zaragoza and Shakhtar. So we have a first decision of CAS saying you owe money to Shakhtar. Then later on, Shakhtar wanted to enforce that decision, and we have a first decision of FIFA saying Zaragoza, in that case, at the moment also the player, but Zaragoza, you owe money to Shakhtar. Please pay Shakhtar in 90 days, or you will get, or you eventually will get appointed action. So what happened then? Obviously, the time elapsed, and in the meantime, Zaragoza entered into insolvency proceedings and was declared, in fact, insolvent. So next thing that happened was obviously, Zaragoza was not so happy with the first decision of FIFA, appealed to CAS, and CAS confirmed the decision of FIFA. So 90 days elapsed, no payment. So again, Shakhtar reacted to that and requested the pointed action against Zaragoza. What happened there is that the new element of insolvency came into play. And what FIFA did at that moment was to say, we have to close the case because of these insolvency proceedings. That was appealed. Shakhtar was fighting strong, and in fact, it derived in a first, let's say, first big stone of this case, which is the CAS of 2012, where the CAS was saying, FIFA, you did wrong by closing. What you had to do was to suspend and resume once the insolvency proceedings were done. So time and time passed, and Shakhtar requested time once and more for the pointed action against Zaragoza without, in principle, any reaction of FIFA. So first reference, what we have there is the first case, is that denial of justice. But if you see the dates, months after, FIFA did render a decision by saying, oh, surprise, surprise, we close the proceedings because there was an insolvency procedure going on. So obviously, what Shakhtar did was to appeal. Why? Because they had already a previous decision saying that FIFA did wrong. So why is FIFA again closing when CAS already told them that they were wrong and they couldn't close? I will explain that because this is extremely interesting, and I think this is why I chose it, because it's extremely interesting from the factual, and then we move forward for the legal analysis. So, second CAS case is exactly that. Shakhtar complaining because FIFA is doing the opposite of what he was told to do in a first decision in 2012. So, we entered into the case. We have a first question, legal question, is denial of justice and res judicata. First thing, and I think, humbly, I think that FIFA was smart enough to react in the sense that months after the appeal lodged before CAS, FIFA did indeed take a decision, and that was also taken into account by CAS, saying exactly that the denial of justice became moot because there was a decision. Second question, res judicata. And this is extremely interesting for a sports lawyer, because the case appears to be identical as the one in 2012. But CAS was saying, no, you are wrong, the case is different. Why? Because we have new elements. One element is that after 5 years, the insolvency proceedings continues. Second element, and this is, I think, the key point in this case, is that in 2015, in a case also involving the same club, a different decision was taken by CAS, a different one as the one in 2012, allowing FIFA to close the case in insolvency proceedings. And that was exactly the argument taken by CAS to uphold the decision of FIFA. On which basis? First, FIFA is free to define the conditions to recognize insolvency proceedings stated by CAS. Then a reference was made to Article 107 about baseless proceedings. When they come in play, proceedings may be closed if the parties reach an agreement. First thing, I think this is important also for other cases. Second, a party declares bankruptcy, and this is the assimilation CAS made to the insolvency proceedings, treating it as it was a bankruptcy situation of Zaragoza. And third, when they become baseless. Obviously, When I look at the third condition, it's like a little bit like opening the door to more discretion of FIFA. But anyways, normally, the main things are the two first. So what is the purpose of Article 64? It's to put pressure on the debtor to pay. And this is exactly, I think, one of the key elements of Article 64, also looking in a case like bankruptcy and a case like insolvency proceedings. Why is that so? Because we want to pressure the club to pay the debts, but it's also true that if the club is impeded to pay the debts, because insolvency proceedings is a typical case where the debtor is impeded to do that, so FIFA needs to step back. And this is exactly what CAS decided, but it's not an automatic situation. It's on a case-by-case basis, and also having in mind that we need always to balance the interests. The interests of applying the FIFA proceedings, but also the meaning here, the pacta sunt servanda, here the right of the club to get his money deriving from a termination without cause, but also the equal treatment of creditors in insolvency proceedings. So the final outcome was the FIFA Disciplinary Committee performed the balance of interests correctly and was entitled to close the case. So that would be for this first case. A less complicated case, but also very interesting from a disciplinary point of view, is the case of the Hungarian Association against FIFA on a case involving two topics. One topic which appears to be very clear, which is the throwing of objects. It's sadly, this is something common in disciplinary procedures for someone who is working on a daily basis. In a case where bottles were thrown against players and referees, some of the objects hitting the referee. Now, here, even though it's an ABC case, it has also its quite interesting elements. And then, in combination with that, apparently the fans, the ultras, were not so, were a little bit more creative, started to chant also, well, around 50, 60, a term which is culero, which is a term which is an insulting term based on the sexual orientation of the persons. So, what was the fine? 40,000, must behind closed doors, and a warning. Why is this case so interesting? Because as we say here, and this is also the purpose of FIFA with this event, is to bring transparency, to take home some of the criticisms that may be outside to us. And one, I think, which it seems obvious, is that in the use of a clear term which is discriminatory, FIFA cannot sanction on the basis of Article 58 of the Disciplinary Code, which is exactly focused on discriminatory behaviors, and must use another one, which is the Article 67, which is more for the improper conduct of the supporters. Obviously, this is something that we need to analyze and eventually change in the future. And then for the throwing of objects, I think I put it there because I think that has also one interesting element, which is the fact that Article 65, which is the legal basis for this kind of incident, says that obliges the associations to ensure the safety of match official players and officials. So it means, and this is the key thing of this kind of situations, we all know the principle of strict liability. I know some are more happy than others. Obviously, sports organizations may be more happy to find this way than, for instance, the people that are the persons, the associations, clubs that are sanctioned. But this is another debate. But here, I think what is interesting in this case is that you can bring to the panel, to the sport organizations, you can demonstrate that you did everything, but the key point is that when the safety of these persons was damaged, the security action plan failed, and for that you would need to be responsible. In the extent, this is something maybe that can be debated, but at least you would be declared responsible. So that was for me. Thank you for your attention. I think I would give the floor to Maya, because she has very interesting information about the lunch. Okay, so thank you very much.
Before lunch, in case you still have questions, obviously Carlos and Mario are here. So, do you have any questions? No? So it looks like you prefer to go outside for lunch and some bilateral discussions. So please join downstairs at the reception for some lunch, and I kindly ask you to be back here at 1:45, where we will continue. Thank you very much. Yes.